at the time, takes your feeling of everyone saying well, I don't just understand. They probably will make you feel you can get started.
Good morning. This is just like church. No one's up front and no one said good morning. Good morning. There we go. All right. So a colleague of mine mentioned this. I can't claim that opening remark. So welcome to the 2023 rulemaking seminar. I'm John Walls. I'm the chief counsel for the advisory division for the Indiana Office of Attorney General. We are completely pleased to be able to bring this presentation and seminar to you after an absence of a few years due to circumstances we're all well aware of. So happy to get it back up and rolling again. And we've been working on this for quite some time now, and it's been a pleasure working with Budget and LSA to put this together so we can bring you some information we hope you'll find helpful. To be quite honest with you, this is just as much for us as it is for you all, because it makes the process of rulemaking go much more smoothly when people are informed. So I hope you all have your agendas, and for you at home, I know that we're very small in your screen, so I'm gonna wave my arms so you know where I am. But we will be following along with the slides for our online viewers as well. We have a great agenda for you. We're going to start out with George Angelo is going to talk from LSA about promulgation through the register and the administrative code. And then Bill, Anthony, and Philip Gordon from my office will be speaking about the overview of the process. We're going to take a 15-minute break, and then OMB is going to speak to us, Patrick Price and Justin McAdam, on the process overview from OMB's perspective. So I do want to do one thing before we start, actually two housekeeping things. One, make sure you get your CLE forms back in, either if you have them here and you haven't filled out front, Celeste will be taking those. And if you're viewing online, you can email those. That was sent out to you with instructions on how to do that. You have 60 days to get that in or you won't get your credit. So don't delay, do it today. And the second thing is, just in case we happen to go over a little bit, I do want to say thank you to Celeste Croft and Jean Marie Allaire, and also to Kristen Kelly, who's pinch hitting, who helped put the administrative portion of this together for us. It's a lot of work. And Jean Marie was doing it from home over the last week because COVID's hit her household. So she's been doing it remotely. So anyway, without further ado, I'm going to let George speak to us and get us kicked off here on promulgation through the register and administrative code. George.
I'm moving over here so I can see the PowerPoint presentation behind me without straining my neck. And it's not something that when they asked me in first grade what I wanted to do when I grew up was to be a PowerPoint person, but I will do my best to keep up with the screens. As John said, I am the executive director of the Legislative Services Agency. It's a service and administrative agency in the legislative branch of government, designed to assist according to the statute, to assist the legislature with its constitutional duties to be an independent body. That being said, we're one of 16 states in which the legislature publishes a register and administrative code. The usual reason for that, and the reason in Indiana, is that the Legislative Services Agency and the legislature had in 1977 had just finished a decade recodifying and rewriting the statutes. And so they had a body of information and expertise in preparing drafting manuals, codification, and writing documents. The speech today, this portion of the presentation, deals with how does the Indiana Register and the Indiana Administrative Code fit into an agency's obligation to promulgate its rules. The meaning promulgate is not a highly technical term, but it differs and is a smaller subset of the concept of adopting rules. There are two portions to the concept of promulgation. First is to make it known to the public. And the second is to put the law or rule into action and force. The administrative code and register are the primary means that the legislature and the executive branch in the 70s invented to deal with promulgation. It's not the only promulgation activities that an agency would be required to do under the law. At one stage in the proposed rule process, you are also required to publish a notice in a newspaper. There is also a provision that you'll maintain on your agency's webpage, a rulemaking document, both of which are concepts that originally came from federal law. And if you look at your own statutes that create your agencies, from time to time, there's a small number of provisions that indicate that you are to do a few more activities, for example, distributing copies to particular individuals. So you would look to find the promulgation responsibilities in IC 4-22-2 for environmental board, the 13-14-9, and I would also look at your enabling statute just to make sure that you've got a full checklist. That said, that's the minimum requirement. There is also the encouragement in 422-2 that you use whatever additional means you need in order to announce to the public what the rules you're looking at will be and the content of how that's supposed to be done. The original concept, according to the 1970 group that put this together, was that they wanted to eliminate desk drawer rules. So promulgation is a key idea that generated the initiation of the register and the administrative code, and also animates what we're doing at the LSA in the future to improve the process. We are, as I indicated, publishers. We don't do policy. We are not your legal advisors, but we do know how to publish a document. I will talk on a couple of points, but let me go over some of the ideas that we'll look at during my presentation. First of all, the register and code is accessible on the internet. We publish weekly. Everything we put into the register and code needs to conform to the administrative rules drafting manual. Every rule document, and all the related documents related to a rulemaking action are given a document control number. The codification of rules, all the current rules that are in existence at any point in time, are put into the Indiana Administrative Code using a 4-level citation number. And we continually update the IAC regardless of when rules are actually adopted. So it is a full complement of all the current rules that are in force. And in addition to dealing with rules, and not the subject of our discussion today, the register is also the repository for a number of non-rule policy documents. There's a statute in 422-7-7 that directs agencies to send their guidance, their bulletins, their interpretive rules, all those that don't qualify as rules, but explain to the public what an agency's position is, to the Indiana Register for publication. The Register does not publish the notification to the public at every point of where you'll be working on a rule. For example, if you deal with additional activities that are not required by statute, we don't publish any of the notices related to your discussions with the public and other interested parties concerning rules. But given the documents that are required through 422-2, we can deal with the more permanent rules, the final rules, as having 3 checkpoints. They have a notice of intent to adopt a rule. Then you publish a notice indicating that you're going to have a public hearing on the rule. And finally, after the Attorney General and the Governor have approved it, the final rule actually gets published once again. The Environmental Agency has a slightly different process, but it is obligated to follow 422-2 and the provisions in 13-14-9. And instead of being relatively speaking, the difference is there are some naming differences, and they have a few additional procedures, but they follow basically the 3-step approach of publication for most of their rules. Emergency rules are an exception, and the only time they get published or the public gets information concerning emergency rules is after it's been adopted by the agency. There is a procedure called agency correction. And agency correction is when you're doing non-substantive things to bring a rule into conformity, either with the drafting manual or with the changes of name. Federal agencies, for example, changes their names. The General Assembly tells you to change their names, citations change, and all those things can be done fairly quickly through agency correction. And once again, those documents are published only after the agency has actually adopted the agency corrections. And finally, there's the readoption process, which will be discussed later in the seminar. And it has a 2-step approach. You notify the public that you intend to readopt a rule, usually during the 7-year cycle that statute requires. And then after you've readopted it, in most cases, then you just publish that you have readopted it. There is a provision in the current law that indicates that if someone objects to your readopting a rule, that you send it through the regular final rule process, entire process. But most readoptions occur with this 2-level set of notices to the public. The second part of promulgation is that you actually have taken act to make it legal. For statutes, this step is codified in the Constitution, and it requires that all the newly enacted acts be sent to each one of the county clerks. And the assumption was in 1850 that this would be taken on horseback to each one of the county seats, and it would have been a 2-week process for the horses to get to every one of them and the certification done. Because it's in the Constitution, we now do it electronically. but it still takes a little while to get all the certifications in. For rules, you've got a very similar activity. You need to publish the rule and in the adopted rules in the Indiana Register before it becomes effective. And the standard requirement is that it becomes effective 30 days later. Then so that applies to final rules, to the environmental version of final rules, to emergency rules, agency corrections, and to readopted rules. There's the provisions that require this filing and not necessarily the publication in the Indiana Register. So my staff can't get in the way of your actually getting your rule effective. It is filing only, but this is a mandatory requirement. 4-22-2 indicates -44 indicates that if you don't do that, then the rule is ineffective. Originally, the Indiana Register and Administrative Code were published in paper form. It was a lovely document, and when I worked in that particular office, it was all paper, and we had 9 people that did the processing. We're now totally electronic, and the Register and the Administrative Code are only published digitally, and we're down to 2 people in that office. The Indiana Administrative Code and Register can be found on the legislative website. To find it, doing Google, all you have to type in is Indiana Legislature, and it will take you to the website. Then you look under the publication tab, and there you'll find not only the code, the register, and some supporting material, including the drafting manual. We track 37 different types of documents, most of which deal with rulemaking and also the non-rule documents, the agency, the governor's executive orders, and the AG opinions are published into the register. A large number of documents in the non-rule document category are decisions of the Department of State Revenue that are published with the names of the litigants redacted. The register is published weekly. The notices coming from the governor when you deal with final rules and other notices concerning the adoption of the rules are published daily. So once you file it with the legislature, then we publish it as soon as possible so the public can see what has been adopted. But the full text of rules and other documents are published Wednesday at 3 o'clock every week, rain or shine. And if you're actually following this and want to track what you've done, look at Wednesday at 3:15 and you'll see whether it's gotten in or not. How do you submit documents to the register to comply with the statutes? Preferably through electronically. The staff for the administrative register and code are in Indiana Governmental Center North. The location is on the 2nd floor at the east end of the building. But the door has an electronic lock on it. So if you're to hand deliver things to the register staff, please call ahead of time. I've given the email address and the telephone numbers. of the two key persons who deal with the publication day in and day out. They're Heather Jarrett and Stacy Yaki. And they, at one or both of them, will be available physically in the building every regular business day. But we do request that you send material to the register electronically to the extent that's possible. And the email address for this material is register@iga.in.gov. IGA does not stand for Independent Grocers Association. It stands for Indiana General Assembly. There is a special statute that requires agencies to send material to the Legislative Council dealing with the rulemaking process. This material is not published in the Indiana Register, but I thought I would bring it to your attention. It's in 422-2-28. And because it's going to the Legislative Council, it has, of course, has a separate email address. So you would comply with that statute by sending it to legislative.council@iga.in.gov. As I indicated, there is an administrative rules drafting manual. It's designed to have the same sorts of features and much of the same structure as the way bills are put together. The statute indicates that the reviser of rules, which is the publication staff, has the authority to amend the documents to conform to the drafting manual. They lightly use this authority and rely on you to actually draft in conformity with the manual. The manual is included in the material for the seminar, and it is also available on the legislative site under the publications tab. The nice thing about the drafting manual is it has a large number of samples for all 37 different categories of documents that might be published in the Indiana Register. But in addition to reading this material, if you have questions concerning publication, the form that's not necessarily a legal question, but the more mechanical publishing issues, please call Heather or Stacy, and they're there and they know that they're there to help you as much as you can, so you can get your job done. As I indicated, documents are kept electronically with a numbering system. There are two numbering systems. One, each document is given an incomprehensible number code to distinguish it from every other document filed in the Indiana Register. But all documents related to a single rulemaking action are given a common document control number. It's a two-part number with a dash between it. The first part is the year in which the filing occurs, the initial filing occurs. The second part is a sequential number that relates to the number of documents that have been filed in the year. And then it has a final suffix that is related to one of the 37 documents that are required to be put into the Indiana Register. And the benefit of that is that you can trace the history of a rulemaking process and retrieve through the search every document that was published that was related to your particular rulemaking process. We also maintain the Indiana Administrative Code. As I indicated, it is a compilation of the current rules in force that regardless of when the rules were adopted. When you're going through the rulemaking process, you use a rulemaking document, and it looks like a bill in the sense that it has a digest, some additional material, and sections of substantive text. We've carved that up, pull out the rulemaking rules that have been adopted, and it's assigned a 4-level citation number that is identical in format to what the are done for bills. The first level is your title. Each agency that has rulemaking power, and that is identified by what the statute says is the authority that is to adopt the rules, is given a title number. Then there are articles. Then we confused everyone by creating the next level called rules, and then finally sections. So a rulemaking document will have what we call big sections, and contained into these containers will be the IAC numbers. And in order to assign those, if you have questions, once again, talk to Heather and Stacy. It is continuously updated. We add a credit line that indicates the history for every section of rule. We also add and request that you provide us with information concerning the related statutes that are associated with those rules, both your authority and anything that's affected. The advantage is that when we publish the Indiana Administrative Code, we hypertext link the statutes and the authority and affected lines, so you can look at both the law and the rules and have the public look at that. Further, using these the credit line information, you can trace back the history back to 1977. So why go through all this rigmarole concerning rules? In 1850, the people and the legislature knew exactly what the law was, and they created a 4-level categorizing of what the law in Indiana was going to be. And it starts with the core Constitution of the United States and the state, then all the statutes of the General Assembly, then all the statutes of the United States enforced, the state laws being more important than the federal laws, and finally the common law of England and statutes of the British Parliament made in aid thereof prior to the 4th year of the reign of James I. And I will let you guess as to what that is for just a second. But the fourth year, the reign of James the First was 1607, which is also the founding of Jamestown in Virginia. But by 1943, the General Assembly said rules are laws. And that gives it a status as if the General Assembly had enacted it. So within the restraints that the limits that the General Assembly gives you to adopt rules, you are creating law when you're doing rules. And as a result, you have these extra additional responsibilities to promulgate the law. So as I indicated, that we also publish a number of non-rule policy documents. You also publish them for the most part on your agency's websites, but you're also obligated to send them to the Indiana Register. There isn't a particular format that's mandated for them, other than we accept them in Word and we publish them. So that's my presentation, and I'm available for a few questions if there aren't any. And I apologize for this slide, but I just am highly amused by the amount of bizarre stuff that you can get on the internet. So I chose this one for this particular slide. So thank you for enduring me for 30 minutes. And if you have any questions, I'm more than happy to answer them. Okay.
Thanks, George. Just one quick thing. So if you happen to have your laptop or your handheld device and you have email access, everybody online and here was emailed a copy of these slides. We were still working on these pretty late yesterday, so we didn't get them out ahead of time, but they are there. I know we've got some heads in the way of some of the materials, so I want to make sure you are aware that that's there. We're also going to be posting these on our website. I know I'm sure the other agencies will as well. So next we have the Office of the Indiana Attorney General with Bill Anthony and Philip Gordon.
Hang on. No. Yes. There we go. Okay. Can everyone hear me okay? Yes. All right. Weird feeling to be in front of the room at a CLE. Good morning. So I know, as John mentioned, this is our first time back conducting this seminar since late 2019. And, you know, a lot's changed in the world since we last conducted this seminar, but fortunately, rulemaking hasn't really had that many monumental developments. So a lot of this will be information that for those who were at the last one have heard before. For those that weren't, you'll learn some new today, hopefully. So it's good to be back. Nice to be here and provide this information to everyone. See a lot of familiar faces in the audience. There are also several new ones out there. So whether you're brand new to the rulemaking promulgation process or have been doing it for years, we're hopeful that you will gain some valuable insight into the process from, you know, not only George, who was before us, but the presenters from the Office of Management and Budget that we have lined up for you today. As some of you know, my name is Bill Anthony. I'm the Assistant Chief Counsel in the Advisory Division of the Office of the Attorney General. In a moment, you'll also get to hear from Philip Gordon, who's a Section Chief within the Advisory Division. So to start off, we're just going to go through some general kind of housekeeping items and give you kind of a roadmap of what our presentation looks like today. Our discussion will primarily center around the general rule promulgation process provided for at IC 4-22-2 and IC 4-22-2.1. We don't really cover emergency rulemaking in any kind of depth. We'll touch upon it a little bit later. We also don't really cover the repeal, expiration, or readoption processes laid out in IC 4-22-2.5. We'll touch upon them, but again, we don't really cover them in much depth. Finally, we don't cover the environmental rule promulgation process in this presentation, as they have some additional requirements beyond those that are found in the general rule promulgation statutes at 422.2. So each of the ones that I've just mentioned, they have separate requirements. And if you're responsible for such rulemaking actions, we would encourage you to consult your relevant statutes and authorities. So to begin, we'll be presenting a very, very high level overview of the rulemaking process. I'll be focusing more on the statutory side of the rulemaking process, and Philip will be covering kind of what the Attorney General's office does, what we're looking for when you submit your final rule packets to us for our review and approval. He'll be kind of pulling back the curtain, so to speak, on our processes and what we're looking for. Since rulemaking is primarily based in statute, we have arranged this presentation in as linear a fashion as possible to sort of provide some chronology so that we can present this information to you in as effective manner as possible. Admittedly, some of the information here today can be a bit dry, to say the least. So without further ado, we'll begin. So on this slide, we've included a quote from this case because we feel it captures the essence of rulemaking and its purpose. You at the agency level are implementing a legislative mandate by filling in any gaps that may have been left unclear by the enacting legislation through the administrative rulemaking process. The basic principles of rulemaking have been recognized time and again at not only the federal level, but the state of Indiana has adopted and recognized these very same principles as well. So some basic information about the rulemaking process, and we'll start getting down into some of the finer details. Under IC 4-22-2-22, the Attorney General is the legal advisor to all executive branch agencies in the drafting and preparation of rules. In the office, that responsibility falls to the advisory division. So what does this mean for you as executive branch attorneys? It means that we in the advisory division, we stand at the ready to assist you with any questions that you have in the promulgation process. We're also available to you to answer any questions that may arise when you're drafting your rules and anything that you need rule-wise. We are your legal advisor in this regard. We obviously encourage you to seek advice and assistance from us as you promulgate your rules. We would much rather catch something up front or very early on in the process than later, because, you know, if we catch it later, problems can arise with your timelines, affected parties, et cetera. So we want you to be able to promulgate these things in efficient, as effective manner as possible. The general requirements of rulemaking are found in IC 4-22-2, 4-22-2.1, and 422-2.5. Some agencies have additional statutory requirements for rulemaking, such as I said previously, the Indiana Department of Environmental Management under IC 1314. You're highly encouraged to consult your authorizing or enabling legislation for any additional requirements you may have when promulgating rules. So what is a rule? It's always a good question to start with. Pursuant to IC 422-23B, a rule means the whole or any part of an agency statement of general applicability that has or is designed to have the effect of law and implements, interprets, or prescribes law or policy or the organization, procedure, or practice requirements of an agency. That definition comes straight from statute. A rulemaking action means the process of formulating or adopting a rule. It does not include an agency action, which is defined as the whole or a part of an order, the failure to issue an order, or an agency's performance of or failure to perform any other duty, function, or activity under the Administrative Orders and Procedures Act, commonly referred to as AOPA. The Administrative Rules and Procedures Act, or ARPA as we call it in the office, does not require formal rulemaking for a resolution or directive of any agency that relates solely to internal policy, internal agency organization, or internal procedure and does not have the effect of law. So getting back to what George said in his presentation, rules have the effect of law. You'll want to review IC 4-22-2-13C for additional information on when a formal rulemaking may not be required. So keep in mind, and as we touched upon previously, the Administrative Rules and Procedures Act does not apply to an agency action, which courts have defined as an adjudication resulting in an order that applies only to particular parties. Again, think AOPA. So that's a case site for you as well there. So I talk a little bit about the Indiana Administrative Code and the Indiana Register. We're not going to go into as great a detail as what George did during his presentation, obviously, but I think it's important to distinguish between the two and to underscore how that distinction applies. So to start, all final non-emergency rules become part of the Indiana Administrative Code. Provided a link, which I think George did in his presentation as well, to the administrative code on this slide. Documents related to pending rulemaking actions and emergency rules and other things are in the Indiana Register, which we've also provided a link as well. So as you're working through rulemaking, and George brought this up in his presentation, an important resource to remember that's at your disposal is the Administrative Rules Drafting Manual, which is published by the Legislative Services Agency and is available at the link on the slide. So within that manual, you will find many helpful examples and insights that will aid you in preparing the necessary documents to effectuate a proper and legal rule promulgation. So an important thing to keep in mind as you get underway with your rulemaking, the state of Indiana is currently under a rulemaking or regulatory moratorium under Executive Order number 13-03, which that executive order suspends agency rulemaking actions unless meeting certain enumerated exceptions. The Office of Management and Budget, who will present after us, is tasked with reviewing proposed rulemaking actions and determining whether or not such rules fit within an enumerated exception. You'll want to review Financial Management Circular 5.1 in greater detail for the processes and procedures to receive an exception to this moratorium. Also, and goes without saying, for any questions regarding this specific aspect of the rulemaking process, you can consult with the folks at the Office of Management and Budget, who again are here today. So to start, you have 60 days from the effective date of a statute that authorizes a particular rulemaking to begin the rulemaking process. That's provided for under IC 4-22-2-19. If your rulemaking will not begin within that 60-day window, you must notify the Legislative Services Agency of the same. An important practice point, the LSA notice can be submitted after the 60-day deadline, really at any point in the process. And I point on the slide here for an example and further information on kind of what that 60-day submittal or notice looks like that you would be providing to LSA and what they'd be publishing. You can take a look at pages 50 and 51 of the Administrative Rules Drafting Manual, and there's some good context and a good example. So there are statutory exceptions to this 60-day deadline, or where you don't have to file any kind of notice with LSA. For instance, some of those exceptions are the proposed rule amends an existing rule. The statute authorizing or mandating the rule was enacted prior to June 30th, 1995, including the statutes recodified after that date. Or the proposed rule is required to receive or maintain delegation, primacy, or approval for state implementation or operation of a program under federal law. That's just some of the baseline information, and we're going to move into discussing the notice of intent now. The notice of intent is covered under IC 4-22-2-23. You must publish your notice of intent in the Indiana Register at least 28 days before publishing your proposed rule. Must include an overview of the scope and subject matter of the rule, as well as citing to the statutory authority for this rule. In the notice of intent, you must also identify the small business regulatory coordinator, which will include their name, address, phone number, and email address, as well as a small business ombudsman called for pursuant to IC 4-22-2-28.1. So while the Office of Management and Budget is here to provide a more detailed overview of their processes, we're going to give you a brief, very brief discussion on state budget agency and OMB approvals. So as required by Executive Order 2-89, an agency prior to submission of the rule to LSA for publication must submit the proposed rule to the state budget agency along with a written statement setting forth the estimated fiscal impact of the rule on state and local governments. Additionally, the agency must prepare a cost-benefit analysis and submit it to the state budget agency prior to the state budget agency actually approving the fiscal impact statement. All cost benefit analyses are reviewed by the agency's SBA analysts as well as the Office of Management and Budget. IC 4-3-22-14 provides all instrumentalities, agencies, authorities, boards, commissions, and officers of the executive, including the administrative department of state government and all bodies, corporate and politic, establishes instrumentalities of the state shall comply with the policies and procedures related to fiscal management that are established by the Office of Management and Budget and approved by the governor, and cooperate with and provide assistance to the Office of Management and Budget. That's straight from statute. That's why you have to cooperate with OMB. IC 4-22-2-28 provides for the fiscal impact statement processes that you must follow when promulgating a rule. The director of SBA must approve the proposed rule and the fiscal impact statement as part of the overall promulgation process. As a practice point, the fiscal impact statement and cost benefit analysis may be submitted to state budget agency and Office of Management and Budget prior to filing your notice of intent for the rule. For helpful information, again, I'm going to point you to Financial Management Circular 5.2, which lays out this process in much greater detail. Rulemaking dockets. These are required by IC 4-22-2-22.5. An agency must have their rulemaking docket in place from the time you publish your notice of intent until the effective date of the rule. You must keep the docket current and update it as needed, kind of on an ongoing basis. An agency is free to utilize the IoT application or its own website for publishing your docket, but to ensure absolute compliance with the statute, we recommend calling your docket either a rulemaking docket or pending rules, something clear, something easy to understand as to what it is and what the substance of it is. So a rulemaking docket must include the following information: the subject matter of the proposed rule, notices or links to the Indiana Register notices, how interested parties or persons may submit comments, the time frame for receiving comments, where comments in the agency's responses may be inspected, the date, time, and place of a public hearing, any relevant scientific and technical findings where applicable, as well as a reasonable estimate of the timetable for action that an agency must update as necessary or as circumstances dictate. It's also recommended that you include any small business ombudsman comments that your office received. Once a rule becomes effective, you can remove it from your online docket. We'll touch on this a bit more later, but please make sure when you submit your final rule packet to the Office of the Attorney General that you're including a printout or screenshot as well as the hyperlink or URL, whatever, in the final rule packet when you submit it to us, because we'll need to review your docket for compliance with the statutes. On this slide, we've included kind of a sample rulemaking docket so you can visualize what the statutory requirements are for this step in the promulgation process. As you can see, it's a fairly simple document, but it does contain a lot or a plethora of information. Publication. Publication of a proposed rule is governed by IC 4-22-2-24. The proposed rule must be published in the Indiana Register and must include the full text of the proposed rule along with the notice of public hearing and relevant economic impact statement. The publication of the proposed rule and notice of hearing must be completed at least 21 days prior to the public hearing occurring. So since we're now getting into the drafting of your rule, I want to pause here to kind of mention the concept of incorporation by reference, which is provided for in IC 4-1. In essence, incorporation by reference makes an outside document part of the rule. To do so, to properly use the incorporation by reference, the document must be fully and exactly described in the rule. The practical matter, the incorporated document is what we would call frozen, meaning that any updates made to that incorporated document do not become part of the rule. Any document that's incorporated by reference must be filed with LSA in either hard copy or electronic format unless the incorporated document has previously been filed with another rule. IC 4-22-2-21A provides a list of documents that may be incorporated by reference. Such items include a federal or state statute, rule, or regulation, a code, manual, or standard adopted by the U.S., state, or nationally recognized organizations or associations, and certain Indiana Department of Local Government finance manuals and information. Notice of public hearing. Statutory requirements for this notice are provided for in IC 4-22-2-24. The notice of public hearing must be published in the Indiana Register along with the proposed rule. The notice of public hearing must also be published in the IndyStar. And as far as the timing is concerned, the notice must be published at least 21 days before the public hearing. An agency must include the date, time, and place of the hearing. Within that notice, you must also include a statement justifying any requirement or cost that is imposed on a regulated entity under the rule and not expressly required by the statute authorizing the agency to adopt the rule or any other state or federal law. The statement required must also include a reference to any data, studies, or analyses relied upon by the agency, determining that the imposition of the requirement or cost is necessary. A statement must be included that the proposed rule and any data, studies, or analysis relied on for the justification statement may be inspected and copied at the office of the agency. So inadequacy or insufficiency of the subject matter description or the statement of justification within your notice of public hearing does not necessarily invalidate your rulemaking action. However, absence or inaccuracy could be problematic. So failure to include the other required elements within your notice of public hearing may invalidate your rulemaking action. So what's that mean? Just pay attention to the information that you're putting in your notice and make sure you're complying with statutory requirements. So after a proposed rule and public hearing notice have been submitted to the publisher or legislative services agency, the publisher will notify you, the agency, of the intended date of publication and will provide written or emailed authorization to proceed. This authorization will contain the information to allow an agency to confirm that the public hearing is indeed at least 21 days after the publication of the notice as required by statute. So from our review standpoint, within the office, please make sure that you're including a copy of your authorization to proceed that you received from LSA in the rule packet when you submit it to our office. That's one of the things we're looking for. IC 4-22-2.1 provides for a small business impact statement to be prepared. Stated plainly, if a rule will impose requirements or costs on small businesses, the agency must prepare a statement that describes the annual economic impact of a rule on all small businesses after the rule is fully implemented. Small business impact statement must be published with the proposed rule in the Indiana Register and delivered to the small business ombudsman, which that individual is located within the Office of Small Business and Entrepreneurship at the Indiana Economic Development Corporation. And that should be delivered no later than the date of the proposed rule publication. Small business ombudsman is tasked with providing written comments back, and they must do so at least 7 days before your public hearing. Any comments received must be made available for inspection and copying at your offices. They must be posted on your website. So remember your docket. That's usually where you would post those, and made available at the public hearing. The agency must respond in writing to any comments received prior to the final rule adoption. $500,000 economic impact statement. If a rule will have a total economic impact greater than $500,000 on all regulated entities, the agency must submit the proposed rule to the Office of Management and Budget at least 50 days before the public hearing. When you submit your small business impact statement, your cost benefit analysis, and your $500,000 economic impact statement to OMB, you can go ahead and provide the Legislative Council with copies of the documents via email. Those can be received at legislative.council@iga.in.gov. And please make sure that you include that submittal or the email that you sent to the Legislative Council in your final rule packet when you submit it to our office. Cruising right along in the rulemaking process. We now arrive at the public hearing. So that is governed by IC 4-22-2-26. A public hearing may be conducted in any informal manner that allows for an orderly presentation of comments and avoids undue repetition. An agency must afford any person attending the public hearing an adequate opportunity to comment on the agency's proposed rule through the presentation of oral and written facts or arguments. The public hearing must take place on the date and at the time and place stated in the notice of public hearing. If the date, time, or place change, you'll want to publish a notice of change in public hearing in the Indiana Register as well as in the Indianapolis Star. You'll want to take a look at pages 34 and 35 of the Administrative Rules Drafting Manual, which provides kind of guidance in what the format of such such notice of change looks like. So in the course of the hearing may be recessed and reconvened on a different date or at a different time or place by announcing the change at the original hearing before the recess. To properly do this and remain in compliance with the statute, you must record that announcement in your record of the public hearing. No further notice is required if you do it this way. So if you record the announcement of the different date, time, or place of the public hearing prior to you recessing your original public hearing. As a reminder, public hearings conducted pursuant to IC 4-22-2-26 are subject to the open door law. So you'll want to review IC 5-14-1.5. Your record of hearing may consist of minutes or a transcript or even a summary of the proceedings. Individuals in the case of boards, commissions, or whomever the rulemaking bodies are that adopt the rule must fully consider all public comments received at the public hearing. This requirement is set forth in IC 4-22-2-27. Attendance at the hearing or a review of the written record or summary of the hearing is sufficient to constitute full consideration under Indiana law of the comments received. This slide's pretty important. Pursuant to IC 4-22-2-25, you have exactly 1 year from the date of publication of your notice of intent to obtain the governor's approval or deemed approval. If the 1 year deadline will not be met, the agency must submit a notice to LSA before the 250th day after the notice of intent is published. So you'll, 249 and below, I guess, would be best practice there. Any notice submitted to LSA must include the reasons for delay and the expected date of approval. If the rule is not approved or deemed approved by the governor within 1 year or by the expected date in your notice that you filed with LSA, the rule is dead and your rulemaking and a new rulemaking must be started. So you do not pass go, do not collect your $100. You're going back to the beginning and you're starting over. Moving into the final steps of the process, or what we call final rule adoption. IC 4-22-2-29 covers final rule adoptions. Final rule adoption, unlike other steps in the course of the promulgation process, cannot be delegated. The rule must be adopted by the individual or group of individuals in the case of boards or commissions with the statutory authority to adopt rules on behalf of your agency. You'll want to review IC 4-22-2-15 for further information in this regard. If the rule is adopted by a board, commission, or other group, the adoption must take place in a public meeting of said authority. So whenever you have a commission or board meeting, that's where it would be the appropriate time to have a final adoption of your rule. So the final rule need not be identical to your proposed rule, but if it substantially differs, it must be what's called a logical outgrowth of the proposed rule and the comments received in the course of a public hearing. An agency may also consolidate. So a couple other ways to do final rule adoptions. An agency may also consolidate two or more proposed rules as one final rule, or adopt parts of a proposed rule in two or more separate final adoptions. So with that, that is sort of the linear process, chronological process of an overview of adopting rules and getting through the rule promulgation process. I'm going to turn it over to Philip here to my right to discuss our office's review of your final rule packets when you submit them to our office. So thank you for your attention and bearing with me through it. Philip.
Thank you, Bill. Yes, this is on. Exciting stuff, right? I woke up this morning and said, let's. So, I mean, we get this as it's long, it's tedious, it's definitely a long drawn out process. As you know, the whole rulemaking process takes about a year. So it's meant. Trying to walk you through the steps and for your agency to adequately go through the process. So once again, my name is Philip Gordon. I'm a section chief in the advisor's office. I'll talk a little bit more about our section later and what we do and really what our role is in advising through the process. But there's a lot of information you've already heard, ton of information that we've already gone through. Takes a lot. It's a lot of dry information. But there's not really a good way of sugarcoating it, as we know, but we're working our way through the process. Lawyers learn about this process in law school. We learn a little bit. No one really wakes up and says, yeah, let's talk administrative rules today. Fantastic way to pass my day. But you know, for you guys, it shouldn't be a process that's gonna, you know, make you feel like you're out on an island on your own. You know, that's why we're here today. That's why LSA is here. As clearly and as smoothly as possible, and to provide these resources to you for future use as well. We're here to assist, making sure that you're all in a good place going forward. So with that, let's talk a little bit about what our office looks for on the back end of this. So Bill talked about the front loading process that you're all involved with. Once it's submitted to our office, I'm going to kind of go through. First and foremost, all rules must comply with statutory steps for submission. Are all reviewed by our office for form and legality within. The submission packet, so each rule binder, or each rule must have a submission packet, which essentially becomes the binder that you're putting together for our office to comb through. It has a CD, and that typically the CD is at the very, front of the binder for us to reference. It's going to have the rule in Word version for us. There's been discussion, I know, at least internally with us about, trying to shift away from CD, maybe a flash drive or even something that's a cloud submission, which I think. Can you not hear me?
So your max.
All right, we'll work on that. So the CD, again, shifting away from that potentially could be something. Involve IoT and some other folks to, potentially gauge how that would look. I know laptops these days, especially in state government, don't have CD drives. So, certainly being able to beneficial for everyone, maybe in the works. The signature page and supporting documentation and also materials that are incorporated by reference should also be in the binder that you submit. So the supporting documentation, what does that look like? Well, it's going to include copies of all Indiana registered documents. It's going to include the rulemaking docket that Bill talked about. And that's something you should print. You should have your website address on there as well, so we can easily locate it. The economic analysis and related documents, your hearing notices, any public hearing comments, those are very important for us to look at. It'd be great if you provide a summary of those as well, especially if they're voluminous, if you had a number of those, to kind of let us know what those are, how many you've received. The agency's response to those comments, certainly how you address them, whether they were incorporated into the rule or not, and why. Documents related to adoption, meeting minutes, and then a summary of changes from the proposed rule, final rule. So your agencies, you may include additional documents and explanations to help out with the review. If there's a part of the rulemaking process that needs an explanation, please certainly let us know what that is. Include it in written form. If you have kind of an ongoing dialogue within your office explaining what the issues may be, or even if you have emails. We've seen emails submitted before to us, so long as they're not confidential or privileged, explaining really what the particular issue is or how it can be clarified. Those things are certainly helpful for us, with this particular promulgation step. Also in the binder, it's nice to have kind of an index kind of explaining everything that you provided, and also to have tabbed dividers. As much sounds almost grade schoolish, that we're receiving these in a tabbed format. It helps us to quickly reference, one step to the other through the process. And then again, an explanation clarifying any unusual circumstances would be great to have that included as well. Possible actions on our end. So when we review the rule, we can do a number of things. We can approve it, in which case we'll sign it, we'll sign off on it, and then we'll send it over to the governor's office for his approval. We'll take no action on it. Believe it or not, we can take no action if 45 days goes past, the rule is deemed approved. It's still approved, and it still would be moved on to the governor's office thereafter. We can disapprove it. We can return it to you, the agency, without disapproval. Typically, if we do that, that's because there's going to be a correctable error that you can remedy, and hopefully do that within the timeframes that are provided. And you can also recall or withdraw the rule, which I'll talk a little bit about here in a couple minutes. Hey, some grounds for disapproval. The rule was adopted without statutory authority. That's a big one. That's one of the first things our attorneys in our advisory section look for is whether you really had the authority to do this or not. It's pretty basic. Adopted, whether it was adopted without complying with your rulemaking statute. Whether the changes from the proposed rule to the final rule did not comply with IC 4-22-2-29C. This is the subsection of the rule of statute that talks about incorporation of comments into your rule has to be a logical outgrowth. So any incorporation that you have has to be a logical outgrowth of written comments that you received during the public hearing process. Final rule cannot be substantially different from the proposed rule unless it was an outgrowth of these written comments that you received. Other grounds for disapproval, this is pretty straightforward. Violates or is in conflict with another state or federal law. Our office, we don't evaluate, we don't make policy considerations. We're not the policy makers here. We're not in a position to judge the policy or the technicalities of your rule, except to determine that the rule is within the authority, statutory authority, and doesn't violate any other law. Well, again, as I mentioned, your board, your governing bodies, you're all the subject matter experts. Not going to step into the shoes of an environmental rule and somehow feel like we understand all the nuances of environmental law. So our job's not to step in your shoes, but to make sure that the letter of the law is really followed from start to finish. Okay, the form of the rule. The way the form's drafted, it should be clear, it should be concise, it should be easy to interpret and to apply. When we look at your rules, in part, we look at them similar to the way we look at a piece of legislation. Because rules do have the effect of law. We're looking at it as to whether it's ambiguous. Is it clear? Its intended audiences, the persons that are affected by the rule itself, whether it's a licensee or someone else. And is it clear what the responsibilities and obligations are that the rule's providing? So if it's unclear how the rule will actually work in practice, then that's going to be a problem. So all these are kind of reasons that we kind of make us question the form of the rule. And I think as George, from LSA touched upon, whether the rule uses the format, numbering system, standards and techniques, all those established by LSA under 422-2-20, that's something else we look for from a form standpoint. What else? If the rule does not comply with form requirements, our office may disapprove the rule or return it to the agency without disapproval, as we discussed in the previous slide. Returned to the agency, it can be corrected without readoption under IC 422-2-32E. So that applies if you still got time, within that 1 year time frame. So long as there's still time for us to approve it and also time for the governor's office to approve it. So always remember that clock is ticking. The 1 year is always kind of ticking along from the date of publication of your notice. We again be cognizant of the timeframes that we have to approve your rule for 45 days and also the governor's office, which can be up to 30 days. Okay, a rulemaking action that does not comply with IC 4-22-2 does not have the effect of law. So 422-2 means the promulgation steps generally that we've outlined. So if it doesn't comply with the steps, it doesn't have the effect of law. It's pretty simple, straightforward. We require supporting documentation to determine compliance with those steps, as we've kind of indicated. That's why the binder organization, ABD process that we have here, the explanations that you provide to us with any deficiencies through the process, all these things are crucial to us to kind of examining your rule and really streamlining the process. And as I may have inferred, as a courtesy, we submit the rule on your behalf to the governor's office after we've approved it. Historically, someone from our office will run it over, walk it over, and physically drop it off. So there's no, getting lost in the snail mail type issue or anything like that. As I mentioned, the governor can approve or disprove the rule with or without cause. So it doesn't need a reason to disprove it. He has 15 days to take action and can also request an additional 15 days. When we talk about that year time frame, you almost can knock off or whatever 75 days. If my math is correct, just based on the amount of time that we have to approve it. And generally we don't take 45 days. If the rule is a little more complicated or does have issues, then we can get up against that window. But we generally try to push them through our office pretty quickly if we can. So after the governor's approval, the rule is submitted to the publisher for filing. LSA accepts it for filing and publishes a receipt in the Indiana Register. Rule takes effect the later of 30 days after it is accepted for filing or the effective date stated in the rule. Okay, a recall of a rule. So what does that mean? So a recall can be recalled by the agency at any time before it's accepted for filing. And I guess the effect of a recall is that it effectively unadopts the rule. So the adoption process kind of takes a halt and it becomes unadopted, and it voids any approval that was given after the rule was adopted. I think you can even unadopt a rule or recall it even after our office perhaps has approved it. It can even be called after that point. You can then readopt an identical or revised version of the rule, and then a notice of recall is published in the register. And I think I referenced page 39 of the Administrative Rules Drafting Manual because it does provide a little more insight, provides an example about what a recall looks like. So certainly. From recalls to a withdrawal, the agency, you as the agency may withdraw the rule at any time before it's accepted for publication, but a withdrawal actually terminates the rulemaking action. So if you withdraw it, that's it. You're done, and you must initiate the rulemaking process all over again. Notice of withdrawal is published in the Indiana Register, and made a separate reference there to page 40. So the other one was on 39. This is on page 40. Same deal as a nice, good example of what this looks like. Other rulemaking actions, readoption and expiration under IC 4-22-2.5. As I think you know by now, rules expire after 7 years, January 1st of the 7th year after the effective date, unless it's been readopted. Submit notice of readoption to the Indiana Register. There's a statutory reference there. You cannot readopt after the expiration date, so pay attention to when your rules expire. If it expires and you don't notice it, then you have to start the process over again. And certainly we work a lot with agencies, we work a lot with state boards, and they're always cognizant of those dates, but at the same point, they're cognizant of whether the rule should be readopted anyways, or whether in fact it needs to be changed or updated. So, certainly pay attention to whether this is something that is even in effect, whether the rule has any application in practice to your agency, and also pay attention to whether, this is something that needs to be amended. Because if the rule needs to be amended, then at that point you kick back into the full promulgation steps. Agency corrections. So I think George may have talked a little bit about, what an agency referenced it, but there's the statutory reference at the top there. And what this does is it allows, certain non-substantive rule changes, typographical or other errors, or to update certain outdated statutory citations or statutory references to be permitted without having to go through a full promulgation, notice and comment, all that stuff. So these are permissible. They're exempted from the normal steps that we've discussed this morning. They're really very limited circumstances when you can do this. And I know our office has gotten a handful of questions from agencies when, they ask, the agency has something very fact specific on whether it falls under this umbrella. Sometimes it does and sometimes it doesn't. But I certainly encourage you, if you do have those questions, instead of just, moving your way through the agency correction process and submitting that to the publisher, if you want to reach out to us and ask those questions, we're certainly, able to help you out. And then after you've done the process of correcting the non-substantive rule change, you go ahead and submit that to the register for filing. Okay, emergency rulemaking, everybody's favorite. Emergency rulemaking can be found at 4-22-2-37.1. The agency must have emergency rulemaking authority and statute to move forward. I mean, this is pretty simple. If you don't have that authority, you can't make emergency rules. It comes from the legislature. The scope of that authority differs from agency to agency. Sometimes it's similar, but it is different depending on what your agency has been permitted to do by the legislature. But most procedural and notice requirements do not apply to emergency rulemaking. And part of this is because emergency rules are meant to be an emergency, and they're meant to be put in place because there's a particular need for that, temporary in nature. They expire 90 days, generally after accepted for filing, unless your agency statute provides for a longer period. So consult your statutes because it may be a little bit. And then generally under 37.1, they could be extended once for an additional 90 days. So you're looking at about 180 days where these rules can be in place. And LSA maintains a great list with all the agencies with emergency rulemaking authority, and that's been updated. Okay, so now just want to sum up a bit more about our role here on the back end and advisory in the Attorney General's office. So we're the legal advisor to all state agencies, drafting, preparation of rules. Established that by now. But the advisory section of our office, we're primarily tasked with assisting agencies with rule drafting. So we're comprised of 12 attorneys and 2 assistants. And each one of our attorneys reviews rules as they're submitted on a rotating basis. Advisory attorney, they do a great job. I know of collaborating with you when you have questions, concerns, and certainly offering solutions on these questions. I've said it before, don't hesitate to reach out. We have some of our attorneys that may have more of a subject matter expertise, depending on what agency you're at, and other attorneys may have more of a generalized knowledge. So you're not going to necessarily, just get Bill or I reviewing these. You may get someone else. Okay, pre-review. So this is part of, I guess, the process on your end, where you can kind of take more of a proactive approach to rulemaking. And you can request our office pre-review and take a look of your proposed rules and other documents, your hearing notices, impact statements. And, we highly encourage this when, there's going to be form or legality questions. Or pre-reviews will also be assigned to any of our 12 attorneys, and they'll work directly with you on getting you a response to that. So pre-review it can facilitate final rule review, but it doesn't guarantee that, hey, you send it over the OAG's office to our office. It's fine. It's good to go. That's not always the case because other things inevitably can come up during the promulgation process. So, okay, I think we're close to wrapping up here on our end, at least with these slides. So again, please reach out to us, if you have questions that do come up. As a last point of emphasis, at least with in the presentation. The rulemaking process, everything we just went through, as much as it's formulaic and it's down in writing, it can be changed. And we know this, and we know it's been changed in the past. It's a construct of the legislature. And there's plenty of bills working their way through the process right now that we know about, that could potentially change some of these requirements that you have. So again, we'd encourage you to pay attention to what's going on with the legislature, see potentially what could get passed, and how it really may affect your agency and some of these steps that we've discussed today. And then just at the bottom there, that's Bill and I's contact information. Jean Marie Leisher with our office, she's senior paralegal, and Celeste Croft is our executive assistant. They're both fantastic, and they can work with facilitating any questions that you guys have as
well. How about that for a disclaimer at the end of the presentation? Everything we just said can change. So
just said that at the beginning.
should have said that at the beginning. Yeah, that's right. Talk about some pitfalls and problems that we still have some time left, right?
Through a couple other items.
All right, so incorporation by reference. This is a big issue that we see in our offense more often than not. As a reminder, IC 4-22-21 limits what can be incorporated by reference. So make sure you review that during your drafting process so that you're in compliance in line with those requirements. Again, we're going to underscore this. You must fully and exactly describe whatever document it is you're incorporating. Oftentimes, we will have to work with agencies because we see a lot of just a lack of specificity, language that's too general to properly incorporate something into the rule. So just make sure that you're fully and exactly describing it. Also, make sure the public has access to the document that's incorporated. Rulemaking, as Philip kind of mentioned, the amount of time it takes, it's a very deliberate process, but it should also be a very transparent process. So we want to make sure the public has access to whatever document it is that you're incorporating. Philip? Yes.
Copyright problems, yes. This issue is in flux. The current, there are a couple of cases that indicate that if it is a matter that's incorporated by reference and it was designed to be something that a state would put into a rule, then it doesn't matter whether it has a copyright or not, that the article can be, must be made available to the public, because under the general concept that it's unfair to expect the citizens to comply with something that they can't see. Though none of those cases have been definitively decided in Indiana. As far as I'm aware, I defer to the AG's office. The Supreme Court in a state Supreme Court in a footnote indicated their displeasure with the the fact that the copyright law has not been definitively decided. But with respect to that issue, this is exactly the sort of issue that you would need to take to the Attorney General's office, and they can give you a legal rendering. There are some sources, as I indicate, that they can look at and give you a pretty good indication of how to proceed. From the standpoint of the Register and the Administrative Code, if it's published in the Register and the Administrative Code as opposed to being incorporated by reference, we hold no copyright on it that would stop its publication by private entities. So it's probably more than you wanted to know. The answer is go talk to your favorite Attorney General.
So our contact information's up there. If you want to email us that question, we'll be happy to look at it further for you. For our purposes, you mentioned copies, how many copies you have to order. We only need the one copy for our review purposes. So, yeah. Yeah, shoot us an email. We'll look at it.
Okay, we got a few more minutes here. A couple of the other pitfalls, kind of issue. I'm going to go back to the concept of the logical outgrowth of changes that happen in the rules, because we do see this happen quite a bit, where a rule will be submitted to our office and it'll go from proposed to final form, and there will be rather substantive changes that will be made. And there's not necessarily an adequate explanation to us as to why, or necessarily a obvious reason. One, maybe because the written comments were non-existent, or they just weren't explained adequately to us what they were. So to reiterate again, any changes must be a logical outgrowth of the proposed rule itself and has to be supported by the written comments during the public comment period. It's acceptable to seek comments to facilitate a change. So if you, as an agency, understand, that, hey, we've learned a lot about from where this rule has gone from proposed form to its final version, and we understand now that there might be some issues with it that we either need to address or include, you can facilitate those comments. You can ask, you can reach out and say, hey, can someone, maybe you have points of contact that can submit comments, but they have to be real comments. They have to be real in written form to trigger this logical outgrowth test. And an agency cannot submit their own comments on their own rule. So that was just, yes. Yeah, so right, and it's very general. I mean, the term itself is it's a very general term of art, I guess. But it has to be, in essence, it has to be supported. It has to be something where it's logical enough that it's without diving too much in a word game here. What the rule content is and what the rule is actually seeking to accomplish. That the comments are relevant and they're related directly to that particular rule. I mean, if you have comments that are made and they're done because a person maybe just disagrees with something that may be wholly unrelated to the rule, and then somehow the rule is changed in a completely different direction that otherwise is not supported by any of those comments, then it's not an outgrowth of them. So if you do have questions on whether, hey, we want to incorporate this into the final version of the rule, the final text, and we think that, these comments that we receive, I think we're covering it, right? We address these three comments in this, in essence, we're covering those three comments with our change. As part of the process, if you want us to look at it, we certainly can do that and say, yeah, it meets the test. And there's some case law out there. There's other things that we kind of support it. Sometimes a very subjective reading, I guess, depending. But in the end, it just has to be supported. Correct. Does not have to be word for word. That's what John said.
So another area we see of concern, small business economic impact statement. So keep in mind what statute considers a small business. That's defined at 5-28-2-6. And just the definition, on at least 50% of the working days of the business entity occurring during the preceding calendar year, the business entity employed not more than 150 employees. And the majority of the employees of the business entity work in Indiana. So that's a small business for the purposes of a small business economic impact statement. Keep in mind, if any cost, and I underscore any cost or any requirement is imposed on any small business, the statutory requirements are triggered to prepare a small business economic impact statement. And again, those content requirements are found at IC 4-22-2.1-5. So sometimes we do see where a small business impact statement isn't prepared or not adequately prepared. The best practice and what we've come up with to use if a small business economic impact statement's not required, just use some simple statement like no costs or requirements are imposed on small businesses. Done. But whenever there's any doubt as to whether or not a small business economic impact statement is required, just go ahead and proceed with the statement. That's our advice.
And lastly, real quick, just a few other miscellaneous concerns. I mean, believe it or not, more often we do see, from the onset in reviewing these rules that the wrong statutory authority is cited, or you only cite one portion of your authorizing statute, not others. So pay attention to those, pay attention to your deadlines. And as I mentioned, that not only ourselves, but the governor's office has enough time to review these. The public hearing timeframe is another thing where we've had some issues with, where you don't give it the full 21 days after the date of publication of the proposed rule. Sometimes we'll see it at 14 or 17 days. So make sure you're complying with that. Always don't forget the 1-year time frame is going to be hovering over you. And then lastly, for us and our own purposes, make sure all statements, materials, other documents, all necessary documents are included in that binder for us, so that the process goes as quickly and smoothly as possible.
And just to wrap up, we're here to help you. So if you have questions, don't ever hesitate to reach out. And we'll be happy to look at those questions and help you through the process. That's all we got. That's it for the Office of the Attorney General. If there's any questions, let Philip or I know, but otherwise we'll probably take a break, right, John?
That's correct. Before we do that, a couple of things. First of all, I want to thank everybody for the morning presentations. They had a lot of very detailed material. Nice job, George, Bill, Philip. Thank you very much. And then before we break for 15 minutes and come back at 11 o'clock, I have to correct myself. You have 30 days to get your CLE form in, not 60. I was told by my person watching from home who has COVID, 30. So it's 30 days. Get them in today. Make it an easy thing to begin with. We'll see you back in 15 minutes, 11 o'clock, and we'll start with the finish up the morning. Thanks.